The case of R versus Mlambo, 1957, Volume 4, SA 727, is the decision of the appeal court, wherein the court held that there is no obligation upon the Crown to close every avenue of escape which might be said to be open to the accused.
So I literally didn't cover Advocate George Baloyi's response to the brilliant application by Advocate Onxumalo Ozithulele because I wanted to break down the case laws he was citing. Let me tell you what he did, okay? He stuffed it with case laws just to enhance and make it seem like he's making a valid, plausible argument. But let's break down this first case law that he cites, R versus Mlambo of 1957. There is no obligation on the state to close every avenue of escape which might be said to be open to the accused. In plain English, okay? Because one thing about Advocate Baloyi, he will speak in Latin, he will speak in case laws, just to go high level. But basically, and is Mr. Interpreter translating this for the accused? Based on your comments, some of times it can be really questionable. But basically, in plain English, what is Baloyi saying about R versus Mlambo? The state, aka George Baloyi, does not need to disprove every possible explanation or theory the accused might raise. It only needs to prove guilt beyond a reasonable doubt, not beyond all possible doubt. Do you know that is actually quite ironic, Baloyi? Do you see that he ran away from the usual case that they like to quote and quote and quote until the horse comes alive? R versus Hepworth. Let me tell you what R versus Hepworth is all about. In R versus Hepworth, two men were on trial, but the real issue, the judge's instructions to the juries, because this is set in Britain, okay? But they still use, Judge Rutter has said it as well, that they still use international laws. So this judge, he told the jury to convict if they were satisfied the men were guilty. The problem is satisfied means enough. The word satisfied caused major concern. It sounded way too casual for something this serious. So the Chief Justice Goddard shut it down. He said judges should tell juries, you must be sure of guilt. Not pretty sure, not probably, but completely sure. And then we have Baloyi coming here to tell us, now he's run away from R versus Hepworth, because R versus Hepworth says completely sure. And then now he's saying R versus Mlambo. And now he is saying there is no obligation for the state to close every avenue of escape which might be said to be open to the accused. The state does not need to disprove every possible explanation or theory the accused must raise. It only needs to prove guilt beyond a reasonable doubt. Let's continue listening on. I want to add, though, that the accused version does not have to be convincing, Judge Rata, okay? It only has to be reasonably, possibly true. If it might reasonably be true, then they must be acquitted, even if the state's case seems strong. So this R versus Mlambo, it works both ways. It works for the state, it also works for the defense. But let's continue on.
Then at page 737, paragraphs F to H, deals with the argument that proof beyond a reasonable doubt requires the prosecution to eliminate every hypothesis which is inconsistent with the accused's guilt, or which, as it is also expressed, is consistent with his innocence. The court, per Justice Malan, rejected this approach, preferring to adhere to the approach which at one time found almost universal favor and which has served the purpose so successfully for generations. This approach was formulated by the learned judge as follows at page 738 A to C, and we quote, "In my opinion, there is no obligation upon the Crown to close every avenue of escape which may be said to be open to an accused, it is sufficient for the Crown to produce enough evidence by means of which such a high degree of probability is raised that the ordinary reasonable man, after mature consideration, concludes that there exists no reasonable doubt that an accused has committed the crime charged. He must, in other words, be morally certain of the guilt of the accused, close quotations. And we mentioned in paragraph 7.5 that it must be borne in mind that the credibility of witnesses is not a consideration at this stage unless the evidence is of a poor quality, and we refer to the same case that my learned friend referred to of State versus Mbete and others, 1983, volume 4, SA 627, the decision of the then K Provincial Division at page 263A, the court held that credibility would play a very limited role and the evidence ignored only if it was of such a poor quality that no reasonable person could possibly accept it. My learned friend argued yesterday that the evidence of Mr. Constable Zungu should be rejected, but we submit, my lord, that that can, firstly, my lord, that his credibility plays no role unless it can be demonstrated that his evidence ought to be rejected in total. The court held as follows, and we quote, "At the close of the state case, when an application for discharge has been made, the sole concern is the assessment of the evidence, and credibility is a factor that can be considered at this stage. However, it must be remembered that it is only a limited role that can be played by credibility at this stage of the proceedings." And we bold the next paragraph. "If a witness gives evidence which is relevant to the charges being considered by the court, then that evidence can only be ignored if it is of such a poor quality that no reasonable person could possibly accept it. This would only be in the most exceptional case where the credibility of a witness is so utterly destroyed that no part of his material evidence can possibly be believed. Before credibility can play a role at all, it is very high degree of untrustworthiness that has to be shown. It must not be overlooked that the trier of fact are entitled, whilst rejecting one portion of the sworn testimony of a witness, can accept another portion. And we, in paragraph 7.6, we respectfully submit that Constable Zungu's evidence regarding how he observed all the accused at the Basotho hostel before and after the incident, describing in detail what each accused did, said, the clothes they were wearing, and the remark by accused number 1 that Mr. SENZO MEYIWA has died before his death was publicized in the media, cannot be ignored or be said to have been utterly destroyed in cross-examination. And we therefore submit that the application ought to be refused for this reason alone.
Okay, so I've got a confession, okay? I wanted to be fair to Advocate Baloyi. I know. I said I want to listen to him, and I want to listen to him sentence by sentence, and I want to hear and really understand what his argument is, okay, on why the accused, aka accused number 4, must not be discharged in his section 174 application. So I covered with you R versus Mlambo. Now he's talking about the high degree of untrustworthiness. How can you say the accused have a high degree of untrustworthiness and then immediately after that you speak about Constable Zungu? Let me tell you something, in case you didn't already know. Constable Zungu is definitely on the list, high on the list of untrustworthiness. And Baloyi goes to put on the record that Zungu observed how all the accused at the Basotho hostel were, what they were dressed, their mannerisms before the act of unaliving of SENZO MEYIWA, and then them coming back, and then accused number 1 lamenting before the media even announced the unaliving of SENZO MEYIWA. What has that got to do with accused number 4? He's not the one who lamented it. But Let's continue listening on. Maybe he's going to land his plane soon.
And paragraph 7.7, we refer to the case of R versus Dadla and others, volume 2, essay 921 at 923 F to G. The court held as follows, that, and we quote, "The credibility of a witness is not a matter to which a judge may pay regard to when considering an application for discharge at the close of the Crown case. His sole duty at that stage is to consider whether the evidence advanced by the Crown, if believed, might be sufficient to satisfy reasonable men acting carefully that the accused is guilty of a crime covered by the indictment under which he is charged. Whether the evidence should be believed or rejected is a matter for the triers of fact to consider at the appropriate time." And we close quotation. And we make the submission that the evidence against accused number 4 is sufficient to sustain a conviction.
At the end of this, I promise we'll also have LLBs. So, as I said, we spoke about R versus Mlambo, R versus Hepworth, and now let's go into R versus Laza and the others, and let's tie it into Zungu and why the state seemed to be so desperate to keep Zungu above board. It is because trial judges and magistrates reference Laza when deciding if a witness's identification should be admitted or how much weight to give it. That is why Zungu had to say he knew all the 5 accused. He had to say he knew them because he knew them before the unaliving of SENZO MEYIWA, that's why he doesn't say I met them that day. He had to know them before, therefore making his witness testimony credible. Ladies and gentlemen, that is the law in South Africa. Let me know your thoughts in the comment section down below. Yeah, kuningi, right? Bye.